Good morning. Are you Jamie Story?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the motion?
She will, Your Honor.
Ms. Story, in cause number 23, DCCR 1546, I have a motion to revoke your community supervision. Shows that you were placed on probation February 25th of 2025 for the state jail felony offense of theft of property with previous convictions, and that was enhanced to a third-degree felony because of some prior felony offenses. And it looks like the punishment was assessed at 10 years with a 10-year probation. Is that correct? This motion alleges that you violated your probation. Count 1 alleges that you failed to report to the probation department January 29th, February 12th, and February 26th of 2026. And is that true or not true?
No.
True or not true? Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true?
True.
Count 3 alleges that you failed to immediately report to the probation officer your contact information. And is that true or not true?
True.
Count 4 alleges that you failed to provide verification of performing the community service hours required. Is that true or not true?
True.
Count 5 alleges that you failed to complete the mental health assessment and follow all of those recommendations. Is that true or not true?
True.
Count 6 alleges that you failed to provide verification of completing the theft prevention class. Is that true or not true?
True.
And finally, count 7 alleges that you're behind in your court assessed fees. And is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 7 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're all actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow this agreement that you've made that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've made is for a cap of 6 years in prison, which means if I follow that agreement, I can give you 6, I can give you less than 6. It'll all depend on the information that's brought to me when we come back for a sentencing hearing. And is that what you want me to do?
Yes, ma'am.
All right, state tenors number 1.
No objection.
It's admitted any evidence Ms. Story is not competent.
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 1 through 7 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, but I'm going to reset your case for sentencing so that the probation department can do an updated report. Also, anything that you think is important for me to know, get that information to Mr. Rojas and he'll present it to me on your behalf when we come back. All right, you can go back with the baby.
All right, thank you.
Judge, my last one is Willie Pugh. He was set yesterday for a suppression hearing.
Let me just Washington Wood Jr. And Mr. Wood, in cause number 25, DCCR 1650, you're charged with a third-degree felony offense of failure to comply with sex offender registration requirements. That's from July 30th of 2025. The indictment alleges that you were also previously convicted of burglary of a vehicle, a third degree, burglary of a building, a second degree, another burglary of a vehicle, third degree, and an unauthorized use of a motor vehicle, a third degree, on January 27th of 1986. And after those were final, you were convicted of theft, a third degree, January 22nd of 2019. You guys have marked off second degree, but would it not be a habitual?
It's not habitual because
It could be because they did not include in the indictment the underlying sexual assault offense that caused him to have to register.
Okay. So
That would be a notice I would make
a
on
notice,
my own.
and that would make it a habitual, correct? So, Mr. Wood, I want to make sure you understand that if you go to trial and you're found guilty and the state files that notice of enhancement with the prior felony conviction that's not in this indictment, that you could be considered a habitual offender with a minimum punishment of 25 years up to 99 years or life in prison. Do you understand? And I have a plea bargain rejection here on the tablet that you've signed with Mr. Parker that shows that the district attorney's office has made an offer. If you wanted to enter a plea of guilty, looks like to go forward probably on count 1 only for a 10-year term in prison. You have every right to reject that and have your case set for trial. I want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to plead guilty. Do you understand all of that? Sorry.
Yes, ma'am, I understand.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
Is there any reason to believe that that offer would change, Ms. French?
Mr. Parker may have information for me that might cause that offer to change. Can we reset? How long, Mr. Parker? What do you say?
I mean, I don't know what I'm gonna provide you other than what I've told you. I'm not gonna have any documentation. I mean, he's on parole, Judge. He has 2 types of cancer. He has some health issues and quite bluntly, he's, anytime he gets, he thinks is a death sentence. And so, I mean, that's his position, understand it. But I don't know if his position is going to change.
So let's just do this. So, Mr. Wood, I'm going to place your case on the trial docket. If anything changes between now and then, the attorneys can let me know. We can get you back in here sooner. Mr. Parker has been appointed to represent you at this point. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and I can appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am.
All right, so Mr. Parker, you're released. Mr. Wood, we will appoint someone today. They should be out there to see you very soon to begin preparation for trial.
Judge, I have the McWade file.
Young? Yes. And Mr. Parker, will your client waive the formal reading of the motion?
She will, Your Honor.
Ms. Young, in cause number 24, DCCR 0402, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 6th of 2025 for the 2nd-degree felony offense of assault on a peace officer, and that was a 5-year deferred probation. Is that correct?
Yes.
This motion alleges that you violated your probation. Count 1 alleges that you committed the new offense of hindering apprehension or prosecution November 18th of 2025. And is that true or not true?
True.
Count 2 alleges that you violated the terms and conditions of your probation by knowingly associating with and harboring Raimi Jamal Prevost. And is that true or not true?
True.
Count 3 alleges that you provided a urine sample April 9th of 2026 that tested positive for marijuana. And is that true or not true?
True.
Count 4 alleges that you failed to provide verification of performing the community service hours. Is that true or not true?
True.
And count 5 alleges that as of April 15th, 2026, you were $308 behind in your fees. Is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 5 freely and voluntarily?
Yeah.
And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yeah.
Do you fully understand them?
Yeah.
And do you understand if I follow this agreement that you'll be waiving or giving up any right to appeal?
Yeah.
And it looks like the agreement that you've reached is for me to continue you on probation, extend that probation 2 years, and also order that you enter and successfully complete the cognitive track of the ISF program. Is that your understanding?
Yes, ma'am.
State tenders number 1.
No objection?
It's admitted. Is there any evidence that Ms. Young is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. This is a big opportunity that you're getting today. I'm going to extend your probation for 2 years. I'm going to order that you enter and successfully complete the cognitive track of the ISF program. If you do all of that, you're still in a great position because you can still finish this probation and not have a conviction on your record. But you're obviously going to have to make some better decisions. What's the relationship with?
That's the problem.
Your Honor, the court amended her probation several months ago, ordered her to not have any contact with Mr. Prevost. He is, I believe, awaiting sentencing or waiting disposition of a aggravated assault motion to revoke probation next door.
Okay.
He is out, and she needs to be aware that she needs to cease communication with him.
No.
I mean, if you were already told that, and I'm having to tell you again, then you're not going to be told a third time.
Yeah.
I don't care what the relationship is. It's up to you to decide if that relationship is worth you going to prison. So, because that's where you'll end up if you're back in here, So I can't imagine that any relationship it would be worth that. I hope you take advantage of this. This was an agreement that I followed, so I'm handing you the trial court certification. And you'll go to ISF, and then when you're out, just do everything you're supposed to. All right?
For 90 days.
Yeah, I think it's close to 90 days. All right, you can go back with the bailiff. Mr. Nichols, have you had an opportunity to review your file?
I have, Your Honor. It appears that there was a bond hearing May 5th, 2026. And I think the court heard evidence at that point concerning this offense and another offense.
I did. I mean, but there was a previous one. I don't know the exact date, but it was sometime. It was just like, let's see. So is there any change that you see, Mr. Nichols?
No, Your Honor, I don't.
Any reason would you, any agreement or reason that I would reduce the bond?
No, Your Honor. I would just re-urge everything that you've been over before, and ask you to keep it how it is.
Give me just a second to go back and look at the PC to remind myself what the allegations were.
The allegations concern him having a fight with a female in the vehicle, stabbing her with a pocket knife while she was driving, and then causing the vehicle to crash.
We naturally kind of disagree with her version of the facts.
Speak up, please.
We naturally disagree with her version of the facts. Mr. Mullins and Mr. McWade were in a relationship, and this was a fight that escalated. Changed since the last time is he now has definite employment waiting for him at Neutron Electric. What is their name? Neutron Electrical. He's a electrician and would go there and work and live at home with his parents. And have nothing to do with Miss Mullins.
Give me a second. I'm just looking at a couple of things. All right, I'm not inclined at this time to modify that prior ruling. I will look back and have the court reporter pull up to make sure that we didn't discuss anything about the job, but at this point, we just need to get the case set for whatever it's going to get set for.
I believe there's been a rejection, Your Honor.
Yeah, it's set for tomorrow.
Oh, it's already on the trial docket.
It's set for September 14th.
Okay. All right, then I'll do my best to see if it can be at the top of the list on that day. If for some reason it's not reached on that week, then at that time I would consider an additional motion,
Okay,
because
thank
I
you.
would consider that new, obviously, if he has to sit and wait for another trial docket. Okay.
Thank you.
All right. Thank you.
Good to see you.
That's an order for a setting.
Well, no,
Sorry, I think it's
Mr. Gertz, you have Giovanni Coleman. Morning.
How are you?
Good. How are you?
See how it goes after this.
Yeah. All right, you're Giovanni Coleman.
Yes, sir.
This is cause number 25 DCCR 0479. Mr. Coleman is charged with the first-degree felony offense of murder. And what is the the announcement?
Judge, we are very, very close to an agreement that will resolve this case without a trial. There are some technicalities that need to be worked out and need to be approved by various people. I think Ms. Alfino will agree with that assessment. But we believe this is going to get resolved. Mr. Coleman agrees in principle with the deal that we have worked out. So,
Speak up.
I'm sorry. Mr. Coleman agrees in principle with the deal that we have. So we're asking for.
And Judge, if I, may I just put my spin on that?
Please.
I would-
Because, and here's
I would
my
not so
concern.
strongly say that we have an agreement in place. It's not like we're waiting for the ink to dry. I think what we're saying without saying it so much is that we have had a very productive conversation, which a lot of times in these elevated first degree cases, we're not even able to get to that point. I'm not in a position to make the offer that we have discussed. And if that requires me placing it on the trial docket, knowing that I need to come to the court in advance, if that offer does make itself
Here's what we're gonna do.
doable.
You've been on since last May, so we're 14 months into your representation. I'm last reset, figure out what you need to figure out to whatever the offer is, it is. I want a final offer, yes or no to take it or not, and then if it goes on the trial docket, all of that needs to take place between now and that next announcement.
Okay, we're ready.
This
for
will
that.
be the last one.
Okay.
Okay? All right, you go back with the bailiff.
And that should also dispose of the code of